Hi, good afternoon, everyone, and thank you for being part of this live stream. I'm David Mahabir, the Wildlife Biologist, Assistant Conservator of Forests, and the Head of Wildlife Section. And I have at my side here Mr. Seepersad, Senior Game Warden II. And we'll begin our presentation. Questions will be answered at the end of the presentation. Any pending question that need to be answered right away, we'll try our best to answer it. So we'll start.
All right, thank you, Mr. Mahabir. Good afternoon, everyone. My name is Steve Seepersad. I'm Senior Game Warden II in Trinidad at the moment. And like Mr. Mahabir said, we are here today to speak to you about the Conservation of Wildlife Act, Chapter 6701, which is very important these days because everything is about the ecosystem, everything is about the environment. So we pay special attention these days to the wildlife laws, right? So the Conservation of Wildlife Act has been around since 1968. In fact, 1958, sorry. It has been, it was actually Act 16 of 1958, and it came into effect as of the 15th of March, 1963. So therefore, it is approximately 64 years old. It was designed to make better provisions for the conservation of wild animal life in Trinidad and Tobago. It identifies offenses and acts as a guide to the enforcers of that act for all the intended purposes. Since the act has been around, there were quite a few amendments. To be exact, approximately 33 amendments, most of which are still in effect today. However, some of which were omitted and deleted because of the fact they were around for a specific purpose and the duration. The most recent amendments, which are still in effect, would be Legal Notice 137 of 2016, Legal Notice 22 of 2017, Act 19 of 2018, which is an important amendment because it addressed the fines. So some of the hefty fines that we have today, Act 19 of 2018, which was done under the Finance Act, is one of the most important ones thus far. We have Legal Notice 280 and 281 of 2019. The Act consists of 24 sections. And under these 24 sections, there are schedules. There are approximately 8 schedules. Now, for the not so legal minded, a legal schedule is a list, a table, a catalog, or inventory of subsidiary details attached to the legislation. From section 1 to 23, there are 6 schedules, and then under section 24, there are 2 further schedules. These schedules are important because during our conversation here today, or presentation here today, we will have the schedules coming up ever so often. So I would like you all to understand what the schedules are. So the first schedule under the section deals with game sanctuaries. It identifies areas in Trinidad where that was designated as sanctuaries, and it also identified the boundaries of those sanctuaries. The second schedule deals with game animals, and this schedule has 3 parts. Part 1 deals with game animals that can be hunted during the open season, and for some of you who are familiar with the game animals would be lap, tattoo deer, wild hog, agouti, alligator, lizards, cage birds. Part 2 of that second schedule has a list of animals that are considered to be waterfowl. We no longer have a waterfowl season in Trinidad. However, it is still a list identifying waterfowls. Part 3 of this second schedule lists all the cage birds that are considered to be cage birds that can be kept captive by cage. The third schedule has a list of animals that are declared to be vermin. What is a vermin? A vermin, of course, is a pest. So that schedule 3 deals with that. The fourth schedule addresses special game license. Fifth schedule, the closed season. As you all may be aware, there is in fact an open hunting season in Trinidad, and there is obviously a closed season. So that is identified in the fifth schedule. The sixth schedule just gives a list of all the persons who are empowered to take action in accordance with the Act. All right. Right. The arrangement of the sections. Starting with section 1, we have short titles. And then we go to section 2, which deals with interpretation and definition. Why this part is important is because of the fact there are words and expressions that are used throughout the Act. And the law lords at the time, or when they write in the law, it was done so that you can actually have a specific meaning for a particular word. So like, for instance, an example, hunt. The meaning of the word hunt means to harass, molest, pursue, wound by any method an animal attempting to capture or kill that animal. So once you see that word appear in the Act further down, you would know exactly what it means. There's also a definition for protected animal, closed season, forest reserves, and so on. Right, section 3. Section 3 deals with offenses relating to sanctuaries. It also gives the chief game warden the power to adjust the boundaries, to add or delete the limits of the boundaries on approval from the minister. And it identifies what is a sanctuary. Section 4 identifies offenses relating to game sanctuaries, like for instance, hunting in a game sanctuary, being found in a game sanctuary, knowingly permitting dogs in a game sanctuary. This actually carries a maximum fine of $10,000. Section 4 also gives the game warden or the enforcing officer the power of suspicion. And by saying that, I mean, if someone is found in the sanctuary, they can be suspected of having committed an offense just by being there. So that gives the officer the power of suspicion. Then we move to section 5. Section 5 identifies offenses in relating to protected animal. And what is a protected animal? I would have just told you all about the second schedule that identifies game animals. And I would have told you about the third schedule that identifies vermin. And the protected animals is now, the meaning of protected animal is an animal that is not specified or mentioned either in the second and third schedule. So anything that was not mentioned before is considered to be protected. So section 5 identifies offenses in relation to being in possession of a protected animal in relation to hunting that animal. It carries a maximum penalty of $10,000 or 3 months imprisonment. Section 6 identifies offenses in relation to hunting on state lands. So apart from game sanctuaries, we have state lands, forest reserves, and so on. So it identifies hunting on offenses relating to hunting on state lands outside of the open season and so on. It also gives the magistrate the power to disqualify offenders from holding or obtaining state game license. So if someone is convicted of an offense of hunting on state lands, the magistrate has the power to disqualify them from holding a state game license. Right, so section 6 deals specifically with state game license. It identifies the terms and conditions of a state game license and, to use a layman language, a hunting permit. It identifies the mandatory data form attached to the state game license. It identifies the consequences for failing to produce it on demand by a game warden. It identifies the penalties in relation to persons being disqualified and attempting. So if someone is found offending or guilty of being found without a state game license and the magistrate suspends that or disqualifies them, from holding a state game license and they attempt to obtain one, they can be fined. It carries a fine of $10,000 or 6 months imprisonment. It also gives, this section also gives the game warden the power of arrest without a warrant anybody who breaches this law. Right, Section 7. Section 7 deals with, it identifies the hunting in the closed season. So persons who may have or is most likely to commit offenses during the closed season, it gives the chief game warden, it identifies offenses in the, of hunting in the closed season. It also gives the chief game warden the power to issue something called exercising permits. And this is actually an issue that most of the hunters in Trinidad have relative to keeping dogs over a period of time in their kennels are not getting exercise, and they tend to say the dogs get fat and the dogs get lazy and that kind of thing, and they lose the ability to hunt. So the chief game warden, this section gives the chief game warden the power to issue exercising permits based on an application from the hunter to exercise dogs. And it also outlines the terms and conditions of that exercising permit, which would obviously be things like exercising dogs. You're not supposed to take firearms, or you're not supposed to take any weapons, or no animals are supposed to be killed. And it must be done outside of the hunting season, which would be probably in the month of September. And it would be given for specifically on private lands, not on state lands, right? And it also identifies the penalty for breach, which would be at $10,000 or 6 month imprisonment. Section 8 is very important because Section 8 identifies the establishment of Wildlife Conservation Committee. The establishment of a Wildlife Conservation Committee acts as an advisory capacity to the minister on all matters pertaining to the conservation of wildlife. And there are stipulations. It must be no more than 10 members. The chief game warden, of course, would be the chairman. There will be a member from the amateurs hunters, field naturalists, senior police officer, agricultural society, somebody from agricultural society, the zoological society, a cage bird fancier, a qualified ornithologist, a qualified zoologist, and a representative of the minister. It also sets out the terms and conditions of that established Wildlife Conservation Committee. Section 9 addresses something called a resident license. Over the years, this is another important issue, because over the years, persons would have entered state lands and game sanctuaries and occupied spaces there. And in doing so, they would have gotten something known as a MOU, or even a squatter's rights. Now, this section gives that person the opportunity to apply to the chief game warden for something known as a resident license. Now, we would have spoken about hunting in game sanctuaries and the offense of hunting on state lands, and the fact that one cannot take dogs or have weapons during the closed season on state lands or game sanctuaries. This resident license is granted for persons who ordinarily resides on state lands or game sanctuaries, and they would be allowed to keep dogs, guns, and other weapons devices capable of being used to hunt animals while that person is a resident. It shall be in the prescribed form and is valid for a specific period. And one important thing to note is that it is not transferable. So someone who has it cannot give it to someone else and they can just occupy. Section 10 gives the chief game warden the power to issue upon such conditions as he thinks fit. Said license entitle the holder or to hunt any animal specified in for the following purposes. Now, a special game license is granted for a specific purpose. It can only be granted by the chief game warden, and it is granted for scientific research, zoological specimens, or the eradication of animals declared to be vermin. And again, I would have mentioned in Schedule 3 what is a vermin. It identifies the terms and conditions of such a license, and the chief game warden can suspend or cancel at any time. Section 11 declares, again, the third schedule declares what vermins are. Now, subject to Section 4 and Section 6, it identifies the terms and conditions of hunting or destroying vermin. Now, the fact that vermin are pests, one thing to note, an important fact to note, is that it is not a pest to the state. So therefore, vermin can be hunted throughout the year only on private lands. If someone is found hunting a vermin on state land, they can be charged. All right. Section 12 is also very important because this is the part of the act that actually gives the game wardens or the enforcing officers certain powers. First of all, the power of suspicion. So during a patrol, a regular patrol, an officer can actually see someone out in the forest or in a forested area and suspects that that person may have committed an offense against the wildlife laws or is in the process or is about to commit an offense. So the power of suspicion is given here. Game wardens also have the power of stop and search someone. They also have the power to enter and search any tent building land without a warrant, except in the presence and with the consent of the owner. They have the power of seizure when it comes to the carcasses of animals or animals in their possession, as well as anything or any devices that were used or is suspected to have been used in the commission of a wildlife offense. And this would obviously be guns, dogs, boats, and even vehicles, right? Section 12 gives the magistrate the power to forfeit any property that was seized, and of course to make an order with respect to the disposal of animal carcasses and meat and so on. Right, Section 13 now deals with offenders failing to give information or giving false information, a maximum fine of $5,000 or 30 days imprisonment. Section 14 gives the power of arrest to arrest a person without warrant committing an offense, whether the name or address is unknown to the enforcing officer. And the enforcing officer also has the right to detain that person at a police station until the name and address could be ascertained. So this is another section that gives the enforcing officer certain powers. Section 15 addresses the issue of assaulting and obstructing an officer in the execution of his duty, a maximum fine of $10,000 or 3 months imprisonment. Section 16 gives the power or empowers a game warden to appear and act on behalf of another game warden. To explain this, in terms of a game warden appearing in court, another game warden can act on his behalf and be afforded the same privileges that a court prosecutor has to question the defendant relative to any offenses or any issues relating to that particular offense or why that person is before the court. So this actually is something that empowers a game warden to be able to speak in court and represent another game warden. Section 17 deals with the compounding of offenses. Now, the minister can grant and may grant in writing and give permission for game wardens to compound offenses, but it must not exceed a $10,000 fine. He can do this by doing something what we call is having the matter settled in-house. So instead of taking a matter to the court, to the open court, once the person agrees and admits to the fact that they would have committed an offense, they can come into the office and the game warden or the senior game warden can deal with the matter in-house and compound the matter. Obviously, a statement would have to be recorded, and they can actually fine that person the sum of up to $10,000 to as compensation for the offense. Now, any property seized can be returned. It can also be based on the value of the property. The game warden can actually find that person and give back that person, return that property to that person. Point to note is that any monies collected, for compounding of that offense must be an official government receipt must be given, and that money would go to the general revenue for the country. A lot of people seem to think that it may go to forestry or may go to the ministry, but no, it has to go to the general currency. Okay. Section 18, exportation of animals. This deals with exportation of animals, which is another important factor because of the fact these days everyone wants to take their pet away. Everyone wants to export some exotic animals. If you are found carrying an animal coastwise without written permission from the chief game warden, you can be fined up to a maximum of $10,000 and imprisonment for 6 months, in addition to any other penalties that may occur. And point to note, all customs laws shall apply as well. So apart from the wildlife laws applying, the customs laws will take effect as well. And again, all compensation, all revenue collected would go to the general revenue of the country and not to the Forestry Division. Section 21 gives the magistrate the authority to award a portion not exceeding 1/2. So the magistrate has the power to grant 1/2 of the penalty that is imposed on an offender to a member of the public who may have been responsible for giving information that led to the arrest and the conviction of that particular person. It will not be afforded to the game warden or a person who was an accessory to that offense, but anybody who gave information relative to that offense and a conviction was secured. Section 22 just gives the information that and allows the fine of $5,000 to be fined or to be levied on a person where there are no fines attached. So any offenses in the act that does not carry a fine, the fine of $5,000 applies. Okay, so we're now on section 23, which is another very important section, and a lot of persons in the country would be asking about this, is the appointment of honorary game wardens. Right, so the holder of the office of honorary game wardens, this was also mentioned in the 6th schedule. The minister, by notice published in the Gazette, can appoint fit and proper persons to be honorary game wardens for the purpose of assisting and carrying out of this act. And honorary game warden shall have all the powers conferred by this act upon a game warden. So it means that once the minister appoints honorary game wardens, person wishing to be honorary game wardens, they would have the same powers and authority under the act as a full-fledged game warden. And they would obviously be covered under the 6th schedule as a person who is empowered, or persons who are empowered to act. Empowerment. Right. So that is the end of sections 1 to 23. We now go to section 24. Section 24 actually gives the minister the power to make regulations under this particular section. He can alter and amend the second and third schedule. He can prescribe conditions for hunting as to the number and sex of animals. He can also prohibit or limit at any time any method for hunting of any animals which appeared unduly destructive or improper. He can also prescribe forms making provisions for the issuing of fees and license. He can restrict or impose conditions for the keeping of animals. He can prohibit the sale or the purchase of meat, wild meat, of course. He could provide generally for the better carrying out of this act and prescribe penalties on summary conviction for the contravention of any regulation. The conservation of wildlife regulations made under subsection 1 may be amended or revoked in this section. So this is the empowerment that the minister has under section 24. Remember I spoke to you about, I would have mentioned 2 schedules under the regulation. So the 2 schedules under the regulation are Schedule 1, state game license. So it gives a clear definition as to what a state game license is, and also the mandatory data form that is attached. The second schedule identifies form of acknowledgement of release of a protected animal. When I spoke to you about protected animal, a protected animal, again, is one that is not specified or mentioned in the second and third schedule of the Act. And this acknowledgement release is for when persons or when officers seize or take animals from persons or protected animals are handed over. This release is given to them, it's written up and it's given to them as an acknowledgement for collecting that animal. So the conservation of wildlife regulation. First of all, regulations are what is known in law as regulatory offenses. It does not carry a jail term, however, it carries a fine. And it is what is known as a strict liability offense. Right? Regulation 2, state game license. It addresses the terms and conditions of state game license, what it consists of, the different species of animals, the different colors, and what is required of the person holding the state game license. It identifies offenses for persons who breach the law by purchasing 4 or more state game licenses, because in the Conservation of Wildlife Act, it is lawful for a person to only acquire 3 state game licenses. So it means that you would be allowed to hunt, a hunter would be allowed to hunt 3 of the species, of the game species, right? So in breach of that, if you acquire a 4th one, you will be liable to pay a fine of $5,000. The state game license, as I mentioned, has a mandatory data form attached to it. This mandatory data form is for the purpose of collecting data. The Forestry Division, the Wildlife Section, to collect data after the hunting season has closed, so we can be aware of the fact of how many animals are being harvested, the species, the conditions and all of that of the animal, and where they are being harvested from. This mandatory data form is supposed to be completed and signed and returned to the Wildlife Section on or before the 31st of May of each year. Now, failure to fill out the mandatory data form is an offense that carries a $2,500 fine, and failing to return it on time without a reasonable excuse also carries a fine of $2,500. So you're looking at a $5,000 fine, hunters. Please be aware of that. Regulation 3 outlines the state game license. Again, it outlines the fee for state game license, which these days, as you all would know who actually take out our state game license, each license carries actually a fee of $100. Regulation 4 deals with the capturing of cage birds and the condition for keeping these cage birds. It deals with the cage size, and it also was amended in 2016 via Legal Notice 137, whereby persons who keep cage birds are now required to have a permit for them, with the exception of budgerigares, cockatiels, lovebirds, and canaries. Regulation 5 states the restriction on the use of artificial lights for the purpose of hunting. This carries a fine of $2,500. A lot of people seem to think that they can go in the forest and use an artificial light for the purpose of hunting. And why I'm stressing on this is because I want you to remember the definition for hunt and hunting. You cannot use artificial lights for the purpose of hunting. Nobody's saying that you cannot use artificial lights while you in your camp or in the forest, but it specifies for the purpose of hunting. Bear that in mind. Regulation 6 addresses, and it was also amended via regulation via Legal Notice 280 and 281 of 2019, whereby you cannot be in possession, you cannot serve, you cannot purchase, you cannot sell, you cannot offer for sale, advertise for sale during the closed season any animal referred to in Part 1 and 2 of the second schedule. Obviously, you can't sell wild meat, which means that you cannot sell wild meat during the closed season. You can't be in possession of it. Also, it amended the law as it relates to iguana, lizard, the possession and the hunting of iguana from the 1st of January to the 31st of March annually. This carries a fine of $10,000. Regulation 7, and this would be very important for very important information for hunters. There is in fact a time for hunting in Forest Reserve, which is actually 5 a.m. in the morning to 7:30 p.m. Anytime you are found hunting outside of those hours, you can be charged. It is an offense. So bear that in mind. 5:30 a.m. to 7:30 p.m. At 7:30 p.m., all hunting must stop. Hunting of lizards within the municipal boundaries of the city of Port of Spain, it deals with that as well. It carries a $5,000 fine. Keeping of protected animals. Regulation 9.1. Right. So this is very important because these is a lot of persons in Trinidad are applying for permits to keep protected animals, and they seem to think that it's an automatic thing. Once they have a protected animal, they can apply, and it's an automatic granting of the permit. What it is I want to say here is that it is in fact the granting of the permit is based wholly and solely on how you acquire the animal, because hunting of a protected animal is illegal. You being in possession of a protected animal, you have to justify to the wildlife section as to how you came about having that animal in the first place. Now, an important point to note is that the Conservation of Wildlife Act gives the definition for protected animal as being an animal not specified or mentioned in the second and third schedule. So what does this say for animals that are not native to Trinidad? It definitely applies to these animals. So if you have an animal that is not native to Trinidad, first of all, you would have to give a reason for having it in the first place, how you came about having a non-native animal. This would obviously be by some form of license or something, importation license and that kind of thing. How you came about it, who gave it to you. And this would definitely add to the fact that whether you get a permit or not, because of the fact we need to conduct a proper investigation. So it is not an automatic thing. So for the persons who advertising online and they're selling animals that are not native and protected animals, please bear this in mind, because the persons on the internet who advertising always mislead the public into thinking that you could just go and apply for a permit and get the permit. Some people choose to keep it for themselves, but if you are caught, it carries a fine of $5,000. Regulation 10 deals with the disposing of protected animals. Now, this addresses the issue of persons who have permits to keep protected animals and decides to get rid of them. You cannot get rid of them just like that. You cannot dispose of them just like that. You need to have written permission from the chief game warden. The chief game warden being the one to sign the permit or issue the permit to keep the protected animal in the first place, must be aware and must give the directive for you to dispose of. So failing to do this, or disposing of without the written permission from the chief game warden, is an offense that carries a fine of $5,000. Regulation 11, it identifies and it gives the game warden the power of discretion. Once an application is made to keep a protected animal, then the application, the enforcing officer would do an investigation, and obviously they would have to do an inspection as to where the animal is and the conditions under which the animals are being kept. So the officer can use their discretion when dealing with issues like this. It also gives the magistrate the power to determine whether an animal is domesticated or not, based on an application made by the offender or the person in whose possession the animal is found. Upon this application, the proof of the animal being domesticated shall lie on the person in whose possession the animal was found. So this gives us an idea as to the power that the magistrate has when it comes to the keeping or the granting of permits to keep protected animals. Regulation 12 again identifies the power of the magistrate. Regulation 13, the forms of acknowledgement for second schedule animals. Regulation 14 deals with, which is a very important point, an important factor, the clipping of the wings of a protected bird. So once you are found in possession of a protected bird and the wings are clipped, you would automatically be deemed as the one who clipped the wings. You can be charged. Apart from being in possession, you can be charged for clipping of the wings of a protected bird. It should not be clipped because of the fact the only defense that a parrot or a macaw has is to fly away. And in clipping the wings, even if you are granted a permit, you cannot clip the wings because the animal may not be able to defend itself and it could get killed. Regulation 15, this is the last regulation in the Act. It identifies the fact that the chief game warden has the sole authority to grant permits to keep birds in Trinidad, and he can also determine the terms and conditions under which those birds are kept or those animals are kept. And this brings us to the end of the Conservation of Wildlife Act. And I now hand you over to Mr. David Mahabir. Mr. David Mahabir, anything you want to add to that, please?
Right. So thank you very much for your presentation, Mr. Seepersad. So we have a couple of questions that came in for the Facebook Live. So one of the questions are, can we hunt manikou on private lands during the close season?
Right, that's a very good question. Like I mentioned in the Act, manikou, based on the list that is available in the third schedule, a manikou is in fact a vermin, is considered to be a vermin or pest. Manikou can be hunted on private lands. Now, point to note, if you're hunting manikou on private lands, you need to get permission from the owner if you are not the owner, because you could get in trouble for trespassing and so on if the owner finds you. So yes, to answer that question, yes, manikou can be hunted on private lands throughout the year.
Nice. Next question is, what is the difference between state land and a forest reserve? Right, so state lands, forest reserve, a forest that is protected under the Forest Act. It's for preservation purposes, and it is part of of course, part of state land itself, but it's specially protected for the purpose of forest species, special species that grow on those particular areas, and also for any of our wildlife that is native to that particular area. As for state lands, we all know what is a state land. State land are government-owned lands that are not private. Right. Next question was, can a person hunt any species listed under waterfowl on private lands in the open season?
No, you cannot. The fact that the hunting season has been revoked via legal notice 280 of 2019, no hunting of waterfalls, private or state lands.
Next question was, has there been any consideration to issue a waterfowl permit for non-migratory birds? So that will be, so far it's on review as our waterfowl permits. As for non-migratory birds, all depending on if it's listed in the schedule that Mr. Seepersad explained under the Conservation of Wildlife Act. Right. Apart from hunting, can a member of the public, example, a veterinarian, legally handle a protected species for the purpose of administering care to the animal?
Yes, of course, and the reason why I say this is because of the fact, obviously, veterinaries have that duty of care, and if someone brings a protected animal to them for medical attention and otherwise, they are obligated to take care of that animal or look after that animal.
Nice. Also, for hunting of animals, is it okay to hunt on your private land with your dogs or on state lands? Someone else.
On your private lands, please notice that once the season is open, you are not required to take out a state game license because it's your privately owned land. You can hunt on your private land during the open hunting season with your dogs.
Okay, so I'll answer this one from Arlene. When will turtle conservation groups be added to be game wardens so that they can handle matters occurring within their communities? So presently, the Honorary Game Warden program is under review. Those who are applied, right now we are in the process of actually selecting the members. So that should be in a time frame, let's say, of about next 3 to 6 months, and it will be, each person will be contacted or been selected to be part of the Honorary Game Warden program. All of the turtle groups, the names have been submitted and under review, and then we'll consider the turtle group members. Also, when will you all be issuing permits to keep parrot and parakeet species? Presently, our the permitting system have been reviewed, is under review. A proposal has been submitted to be approved by the minister itself and the chief game warden. Right now, we are trying to put a proper structure in place so that everyone will get a fair chance to apply, depending on the species and depending on how you acquire it. And so at the moment, we are accepting the applications presently. So you all could submit your applications, and then the game wardens are currently doing their inspections, right? All right, this one is to you. How does one legally acquire macaw? Someone have rescued a macaw, and they're actually wondering why other people have macaws.
All right, so most of the persons who have macaws in Trinidad, they have them illegally, and they would have acquired them illegally. To address the issue of how you acquire macaw legally, we have persons breeding macaws in the country. I know Mr. Panton is one of them. And we have breeders in the country who actually breed in. And of course, if you would have understood the regulation that dealt with the disposal of a protected animal. If someone is the owner and the holder of a permit to keep a protected animal, they can sell it to you. They can give it to you once they have written permission from the chief game warden.
Transfer ownership.
Yeah.
Right?
Yeah.
All right. So our next question from Darrell. When will you all be issuing permits for the hunting season 2022 to 2023? Usually we start at the middle of September, and then the hunting season begins from the 1st of October to the last day in February. Right? So I hope that answers your question. My next question was, can you hunt at night on private or state land? Well,
all right, so state land, obviously not, but privately owned land, seeing that is your private land, yes, you can.
Mm-hmm. All right, next question. Well, what is the regulations for registering wildlife farmer? So right now the wildlife farming program proposal have been submitted for review, and this should be out anytime soon. So those interested in the wildlife farming program, you all could apply at the wildlife section. That says Farm Road in St. Joseph, and we'll be able to, once it's approved, or we'll be able to actually work alongside with you all and show you how to actually do proper wildlife farming, especially with the animals, and have a training session for you, for those interested. Okay. All right, next question from Sarita is, what are the criteria to classify an animal as a vermin? So also there are several bats and snakes that are listed as vermin, with a rampant loss of forest and natural habitat that has possibly affected these species. Doesn't their status need to be reviewed?
Well, first of all, the second schedule, the third schedule, sorry, outlines the list of animals that are considered to be vermin. Mm-hmm. So that is clearly stated in the Act. With respect to bats, Legal Notice 137 of 2016 would have addressed the issue of bats. They would have removed from the vermin species all the bats that are considered to be insect and fruit bats. So they now have two species of bats listed as vermin, which would be both species of the vampire bats.
Right. The next question is, does the capybara come under the vermin list?
Yes. That's a very good question, because this was also identified in Legal Notice 137 of 2016. Although the capybara is not native to Trinidad, it has become a pest in Trinidad because of the fact it was introduced, and it is now there are no populations in the wild in Trinidad.
Right. So next question is, can you share an insight on hunting capybara on state lands occupied by farmers, official and unofficial occupation?
All right. So as I would have mentioned, a vermin can only be hunted on private lands because it's not a pest to the state. So the status of the land that you want to hunt on, as long as it belongs to the state, you cannot kill a vermin, capybara, on state lands. You cannot hunt it.
Okay, so Shiraz, that's a good point, where he's mentioning about forestry students and the general public can involve and participate in activities with Wildlife Division Forestry in terms of reforestation or rehabilitation. So the wildlife section, over the past couple of years, have been reaching out to the public in terms of schools and having volunteers who actually want to work alongside doing projects. I also reach out to a lot of universities and primary schools also. And this is what we do. We try to engage the general public in order for persons to be educated when it comes to wildlife and wildlife species, and not just animals, but also plants as well, and trees. So that's a good question. And any one of you out there who want to participate and be part of the wildlife conservation and protection, you could always reach out to us anytime. Right, I will share my email address and you all could even email me from there or visit at the office at Farm Road, St. Joseph. So our next question is regarding Regulation 14.1.2. Does that mean it is an offense for a veterinarian to clip a bird's wings based on the owner's request? It will be insightful to inform us as vets of what is allowed.
Great, that's a good question, because that question came up quite a number of times. Yes, it is illegal for a vet to clip the wings of a protected bird, whether it's requested by the owner or not. It is against the law, and it's something that you can be charged for. And if you have a permit to keep that bird in captivity, the permit can also be revoked and the animal be seized.
Okay, so we have Susan is asking where in the Act says you can't keep captive bred birds.
The Act makes no mention of captive bred birds.
So please quote the law which states you can't sell captive bred birds in Trinidad. That'll be for my request from the Chief Game Warden.
All right. So the issue is here, the captive bird that you're speaking about, the captive bred birds, as long as they hold the status of being protected, once they're not specified or mentioned in the Act, you cannot sell it just like that because of the fact it is protected. Whether it is imported, once it has the status of being protected, not specified or mentioned in the second and third schedule, then the law applies.
Right. Macaws acquired in Trinidad will have most likely been acquired illegally, which is true.
Yes, of course.
Correct, Rebecca. Next question is, are there going to be any new conservation strategies to ensure overhunting in the open season? So over the past 11 months, we have our additional 28 new game wardens. Because of lack of game wardens and enforcement was very weak. And presently now we have our additional 28 vibrant, active game wardens. And right now they are making the headway when it comes to enforcing the laws, and especially with the hunting season and the close hunting season. A lot of persons have been charged, and this is ongoing.
And of course, we have the issue of the inspection for protected animals and cage birds. We now have a large cadre of officers who are actually out there doing inspections and dealing with that backlog of applications.
Right, true. Also, Rebecca asks, macaws and parrots also outlive humans. So what happens when you die? Who takes care of the bird? Keeping a macaw is similar to keeping a toddler child for an entire lifetime. So to answer this question, you could have a transfer of ownership once you apply to the wildlife section for that, depending if the person has passed away, right?
So again, Regulation 11 addresses that in terms of someone being in possession of a protected animal who had the animal for quite a number of years and passes on, the animal, the person who is in possession of that animal now would not be considered as committing an offense because of the fact it belonged to somebody who had it before, and a permit will be granted to that person who inherits the animal, so to speak.
David Huggins asks, when you go to areas casually, macaws let you know they are there. How are people still able to go under the radar when they have these birds illegally? So most of the birds, especially macaws, are illegally brought into the country, in most cases from the mainland, which is South America. So when persons that you saw that have macaws without a permit, it is illegally being kept. And that is where you can notify the wildlife section and they will address that situation.
Yes, and I want to add to that, Mr. Mahabir, the fact that macaws are pretty noisy, most of the times early in the morning, late in the evening. Persons who keep them without permit kind of keep them strictly at the back of their homes, on private lands and so on. And at some point in time, they will be discovered. So And once they are discovered, we will deal with them accordingly.
Correct. Also, next question is, why are you only allowing permits of parrots and parakeet only to be kept as pets and not to breed and trade? So most of our requests at the wildlife section is usually for parrots and macaws, and well, we used to for in terms of monkeys, but that is not being allowed right now. So in terms of breeding, once you acquire it legally and the game wardens do their inspection and agree that the animal is being kept in proper conditions and proper cage sizes, which you want to highlight the cage sizes for them.
All right, well, this is in terms of cage birds.
Mhm.
Cage birds should be kept. A cage bird should be kept in a cage the size which is no less than 1 cubic foot per bird. Any additional bird, like if you have to keep 2 birds in 1 cage, then you have to increase the cage size by 25%. In terms of breeding animals in captivity, it is not something that is mentioned in the Act. However, if you are allowed or you are permitted to keep protected animals, and let's say, for instance, you obviously have a pair and they breed in captivity, nothing is preventing you from that. You didn't break the law. However, what you need to do is you need to notify the wildlife office that you have eggs or you are expecting offsprings because of the eggs, and you have to obviously bring proof of that, because we would need to know, and we would definitely update the records and, of course, adjust your permit. So there's nothing in law that says you cannot breed, but if it does in fact happen, we need to be notified so we can do the paperwork to deal with it accordingly.
And even if the bird itself passes away, we need to keep it and then present it to us.
Of course.
All right.
One of the things that we should have mentioned also is a protected animal is protected. It's protected whether it's alive or dead. So disposal is very important. So please bear that in mind.
All right. Denisha asks a question. What are the requirements for removing trees in an area that has red howlers, since it is an ESS? So I will answer this question. So removal of trees, whether it's private or state land, requires permission from the Forestry Division, depending on the areas. Now, the Forestry Division, the areas are situated similar to how you'll deal with constituencies. So in our forestry aspect of it will be conservancies. So there will be northwest, north central, northeast, southeast, south central, southwest. All right. So all these areas, there's foresters and rangers and game wardens also in charge of these particular areas. So once the request is satisfied by the Forestry Division, you'll be able to apply for removal of trees. Now, in cases where the red howler monkey, soon to be ESS, environmentally sensitive species, depending on their native habitat, granting of permission to remove trees that serve a purpose for the red howler monkeys or any wildlife species will be considered, and in most cases it wouldn't be granted, especially when the red howler monkeys in most of the areas that they are situated in sanctuaries and protected areas. So we don't issue any removal of trees in those particular areas.
Obviously, Mr. Mahabir, when it comes to private lands, we have no control over that.
Correct.
It's privately owned.
Yep. What other animals are allowed for wildlife farming? As I mentioned before, I have done the proposal for the wildlife farming. It's under review. The wildlife farming, we usually for game species, which be like agouti, lap, deer, iguana, manikou, those type of species. So someone, Susan asks again, so why and when permits are granted to import birds, listeners are not given? So any importation of animals, birds, will have to go through CITES permit, right? Regulations, which is Trinidad and Tobago signatory to CITES, and once the exporting country have done the checks and balances and verify that it's captive bred or it come out from the pool, the wildlife, the amount of wildlife they could export to the importing country. And once that is approved and under review, then we'll grant it. Now, in most cases, well, not in most cases, in some cases, animals are brought in illegally without the CITES approval and permitting system. And that is where some person will apply and it will be refused because they're not following the proper guidelines, international guidelines when it comes to importation of animals and even the exportation of animals as well. Any animals that have been exported from Trinidad, game wardens, together with myself, will do an inspection to verify the species and verify that the animal is captive bred or are not illegally taken from the wild or brought in illegally and then now being exported as a country that has been like a trans-shipment country.
Also, Mr. Mahabir, let me just mention that, of course, I would have mentioned earlier the status of an animal. Once the status of the animal is protected, whether one acquires a permit to import it legally via CITES and all the other necessary documents that you have, once it comes to the country, even though you have importation permits for it, you still need to apply for a permit to keep it as a protected animal. And if the purpose of bringing it was to actually sell it to others, then you have to get written permission from the chief game warden to dispose of. So it's not an automatic thing where you got a permit to import it and you can just sell it to members of the public. It still holds the status of being protected, and the necessary steps to dispose of them would have to apply.
All right. Susan again asks for CITES if we follow the rules. So of course we do. Being all the CITES rule internationally, every single country, which is 189 countries, are part of CITES. We follow this simple rule under CITES that every single country have to abide. So yes, Ms. Neves, it is being followed, and not just Trinidad and Tobago, but internationally and from every other country. So whether you want to export or import, you have to make sure they follow the proper guidelines and that it is legit and legal. Right? That's to ask if some imported birds and they are breeding, why can't they be sold or traded? So once you're breeding in captivity and they reproduce and you want to export it under the approval from the Forestry Division and all checks and balances that it didn't come from the wild, it can be granted for you to export. Right? Serial number, leg tags should be considered for identifying licensed birds. Yes, that's a good point, and yeah, we do that as well. Also, is Forestry Division maintaining blaze lines? Their nurseries fully functioning? Replanting of trees, pine trees, and otherwise? Yes, Anthony. So the Forestry Division, we have a nursery set up throughout in different conservancies, as mentioned before, where we also sell plants to the public, and we also provide forestry species if you want to plant privately. And we also have the community forestry that will give you an idea, depending on the location and the type of trees that you want, and you'll be able to guide you accordingly how to go about planting and if you want to encourage wildlife, what type of species for you to plant, all again depending on the area. Right. Next question was based on the time frame specified for the hunting. Isn't it dangerous to have all hunters going to the bush to hunt in that given time? Now we cannot tell persons, okay, you have to hunt at certain hours. It is up to the person, whatever hours you want, but according to the law, as explained by Mr. Seepersad.
Exactly. So the period for hunting is 5 a.m. in the morning to 7:30 p.m. at night. Anything outside of that is illegal, based on the law.
Yes. Darrell Ramrine, thank you very much. So the presentation will be also on the ministry's YouTube page. Also, if anybody want a request of the presentation itself, that could be provided. You can email me at david.mahabir@gov.tt, and that could be provided for you. Even if you all want to participate and volunteer, or you have any ideas or any kind of initiative that you want to embark on, feel free to contact my office at any time. Right. So next question from Priyan is, are artificial lights allowed during hunting? If not, how come the hunters are not charged?
All right, good question. Remember, Kriyan, I would have mentioned the definition for hunting. Hunting means killing, wounding, pursuing, harassing, or molesting an animal with view of capturing or killing that animal. Artificial lights can be used in a camping area, but for the purpose of hunting that particular animal, it is illegal. And of course, if persons are found, once you have information and you're willing to share, persons can be charged for committing that offense.
Right. Our next question from Priyan is, how does the sale of live injured animals such as iguana factor in during the hunting season? So injured animals.
Unfortunately, Kriyan, there are no laws that deals with this this act in terms of injured animals. Once the season is open and you have a state game license, you can injure an animal and you can sell it, because, especially when it comes to the possession of iguana, because I know persons would have asked before the fact that they actually break the tendons of the iguana and tie it behind their back and that kind of thing. It amounts to cruelty, but I believe the Cruelty to Animal Act addresses some form of that, but in the Wildlife Act it doesn't.
Nicholas Grant asks, can you recall the current ESS listing? If you go under the EMA website, you'll be able to get a listing from there. All right. Next question, can persons with private collections of animals apply to be a zoo? They could apply to by granting through the chief game warden as a rehabilitation place or education for education purpose. Once approved by the game wardens together with the chief game warden and myself. Yeah.
Right. But point to note, private collection. Where was the private collection acquired? How long they had it? If the animals are native, non-native, if they're protected. Things like that would obviously be key factors to take into consideration. And I know right now the only person who has, or the only authority that has permission to have animals on exhibit is, of course, the Emperor Valley Zoo.
All right, Kriyan again, can reptiles legally be imported to Trinidad, such as snakes, tortoise, and lizards? Yes, Seepersad, once it's once all of the exporting country have approved the export of the particular species and it falls under CITES, well, they will actually do their checks and verify that is not illegally taken from the wild. And once that is confirmed, then you could apply for your importation. Next one, how will the public know what is state land and its forest reserve? Is there a map showing this? So it's mentioned on the Conservation of Wildlife Act. Mr. Seepersad had mentioned that earlier on, where you will have the forest reserves under the Forest Act. It's mentioned there. Sanctuaries is mentioned under the Wildlife Conservation of Wildlife Act 6701, and under the Forest Act 6601, you also get the listing of the forest reserves. State lands will be identified also in the map area, but there's when it comes to state lands and private, that's where the differentiation between the two that will have to be done through lands and surveys to verify that particular land itself.
All right, great. I want to add to that, Mr. Mahabir. It's a good question, and point to note is that ignorance of the law is not an excuse. So if you are found hunting on a parcel of land, or if you are interested in hunting, it would serve you right to actually take time to find out whether you're hunting on state land or you're hunting on someone's private land. Because if you are taken before the magistrate and you say that you didn't know or you weren't aware that this was a sanctuary because there were no signs and no boundaries, as the case may be, ignorance of the law is not an excuse.
Right, our next question is, how were these species of birds that are protected in Trinidad came on the list of protected species? So, under protected species would be like species, after doing research and collecting scientific data in terms of the population and the locality of the particular species that are being threatened, they have become protected. Also, with being signatories to international bodies, for instance, like CITES, IUCN, animals that are actually red listed and vulnerable to be extinct would be considered to be protected, especially our local species, which, as we all know, a lot of them are, like, especially our parrots and macaws are protected because you don't really see them outside in the wild. And that's why, you hardly ever see any, like a scarlet macaw flying overhead. And that's why we protect these species itself.
And also you have to be mindful that in terms of the list that is supplied in the Act, the second schedule lists the game animals, third schedule lists the vermins, and it says anything that is not specified or mentioned, the definition for protected animal, anything is specified or mentioned, not mentioned, is considered to be protected. So the Act clearly outlines what, by negative listing, what would be considered protected.
Right. The next question from Anthony is, what is the government doing for conservation? Is exactly what we are doing here, educating the public, doing enforcements. I know our minister himself have been very active when it comes to our preservation and conservation of flora and fauna. And this is why the Ministry of Agriculture are actually doing our outreach program. And hiring of actually 28 new game ones is it's the biggest hiring in terms of game ones in the history of the Forestry Division, even for the country itself. So these are some of the areas that the government presently is being focused in order to conserve and protect our wildlife species. All right. Next question is, why not ban the sale of hunting of wild meat? It will reduce the pressure on the harvest. Now, similar to persons who wouldn't hunt or don't hunt or don't eat wild meat, there are some persons who actually will like to because it's a delicacy or because it's a part of our culture. Now, when it comes to hunting legally and hunting in a conservative manner, this is where it is important. Now, once you overhunt and hunt illegally at off season, this is where the issue comes about. And I understand why you will ask that question. So.
And also the fact that I mentioned Section 8 of the Act addresses the issue of the establishment of a Wildlife Conservation Committee. Issues like these are what the Wildlife Conservation Committee has to make recommendations. They will discuss it and make recommendations to the minister to have the laws amended and so on.
Right. Krian mentioned about the animal welfare laws for all animals, including wildlife, and that's a good point. And this is one of our recent acts that have been implemented in terms of laws. And yes, we need to actually, I know previously Anne-Marie Hussein had done a presentation on animal welfare under the same webinar. So it's there, it's just, it need to be shared more to the public so persons could actually understand when it comes to animal welfare and how to take care of that. Right. What are we doing to protect the last remaining seed eaters from trapping, enforcement, and also just a few weeks back, the game ones themselves had done a outreach program educating persons about cage birds and seed eaters, and we have done a lot of
patrols in the areas where these birds may be or may have habitats. And Mr. Mahabir would have also mentioned the fact that we have a larger manpower because of the fact we have increase in staff, we have more eyes and ears out there, and definitely this is one of the areas that we will be focusing on to ensure that according to the person who asked the question, to ensure that the cities as the population remains or at least increases.
And the reason why I laugh was because the areas that they would patrol, it would be spontaneous, and we know that seed eaters and birds would be specific to certain areas. So the game ones will do their impromptu patrols in these areas to make sure they capture these perpetrators.
And of course, if anyone has information relative to the capturing of these birds, please, you can call and share the information with us.
Last question is, Rennie is asking, he's seeing foreign birds in the arc example budgies. Why is this? Do we need permit to keep foreign birds?
Right. So over the years, persons were allowed to import budgies, lovebirds, cockatiels, and canaries. And legal notice 137 would have addressed that, that they are now included as cage birds, as birds that can be kept captive by cage. And the act also states that no permit is required to keep them. So with the exception of the cravat parakeet that can be hunted, we have the bullfinches, picoplats, shat, nuns, and silverbeaks that you now require permits to keep them in captivity. So you don't need permits for your lovebirds, budgies, cockatiels, and canaries.
Right. Susan again asks about ringnecks, not considered protected on CITES yet. It is not, but at the same time, it is not foreign to Trinidad, and it could be invasive and also be detrimental to our avian population outside there. So therefore, to actually import it into the country, you have to follow all guidelines and all the regulations, also to make sure that it is not, don't have any sort of viruses and diseases that could be detrimental again to our bird population outside there. So yes, you have to follow the legal criteria, whether it's CITES or not, any importing or exporting of species, they need to follow the our laws.
Mr. Mahabir, also, you have to remember that whatever the status may be in another country, once it comes to Trinidad, our local law applies. It's not specified or mentioned in our act, it's protected.
Right. That's it. So again, thank you very much for your time. And again, any further questions, you could actually email us. My email is david.mahabir@gov.tt.
Mine is steve.seepersad@gmail.com.
Right. And also, if actually in the wildlife section area, Farmwood St. Joseph or San Fernando office, you could also pay us a visit to discuss any burning topics or issues that you wanna share with us. And again, thank you very much for your time, for all the comments and all of the messages that came in. I hope we answered the questions. And have a good evening. Be safe.
Yes, have a good evening all. Thank you for sharing this time with us.
Yes. Take care. Bye.
Bye.